Our last speaker will be my former colleague, and now Professor Chen Lei, and he has now moved to the UK. And he's now with Durham Law School, and he's the chair of Chinese law there. So, okay, I will just turn it to you for your speech on comparison between common law in Hong Kong, CISG, and the Chinese law.
Thank you, Chair, for your very kind introduction, and thank you very much for organizing this high-profile symposium on CISG. Just a small clarification. You just mentioned I have been kind of lost contact since I left Hong Kong a month ago. I just moved to Durham. And the presentation I'm going to talk about today is different from the one shown on the program rundown. Actually, the program rundown suggests I'm going to cover a comprehensive comparison between the Chinese, Hong Kong, and CISG. That is something I'm not able to, nor do I have a time to provide a comprehensive comparison. Actually, why I informed you, I meant to present on the topic of change of circumstance, frustration, impediment. And just now, I learned a lot from Professor McKendrick's presentation, but my presentation slanted towards the Chinese law perspective in comparison with common law position. I have to it is meant to be a follow-up conversation of Professor McKendrick's presentation. And Professor Bridge just mentioned when we talk about Article 79, we need to bear in mind some civil law jurisdictions might not enjoy the strict liability contract law regime as common law does. But in Chinese law situation, Chinese law is a strict liability contract law regime. So it's interesting to make a comparison between two. So as we know, actually I have a PPT, but somehow I cannot upload it. Maybe I'm not as techy savvy as many others. But anyway, I just trying to present as it is. As we all know, the COVID-19 virus pandemic brought a widespread economic impact, and global businesses are considering the best way to mitigate unforeseen supply chain issues and contractual performance and the loss of business. Some argue that there would be a legal pandemic after virus pandemic. Parties may also wish to gain a clearer understanding of the doctrine of change of circumstances under Chinese law in order to mitigate the loss if the governing law is a PRC law. Some non-Chinese law experts are of the view that the Chinese firms are likely to get a more sympathetic hearing in Chinese court or overseas arbitration institutions by using the doctrine as an escape route for a party who has simply made a bad bargain. Some even describe the doctrine as an obscure legal maneuver used to get out of the contracts. The central thesis of my presentation today is to challenge this myth. The Chinese courts have employed a more restrictive approach, and it's rare to find the doctrine being pleaded successfully. By drawing on comparative analysis with common law doctrine of frustration, this presentation seeks to show that in reality, as the previous presenters state, there is a practical convergence between the two legal frameworks. I also seek to show that in the exceptional situations where the remedy is granted, modification may prove to be a more commercially sensitive solution than the termination, because it preserves a long-standing business relationship between the parties. So in a business contract without change of circumstance clause under Chinese law, the statutory doctrine of change of circumstance may be applicable to the parties. Where the DCC, the doctrine of change of circumstances, applies, the court has a discretion to decide whether to modify or rescind the contract. This is different from a common law position, where the automatic discharge of contract will be the only remedy if the court frustrates the contract. So the closest functional equivalent of DCC is doctrine frustration. The frustration was developed to mitigate the harshness of absolute contract liability. The rule allows party to be discharged from the contract where there is an unforeseeable supervening event that radically changes parties' original bargain. Nevertheless, the doctrine of frustration is narrow and inflexible as articulated by previous presenters. This can be seen in the Canary Wharf versus European Medicine Agencies. In that particular case, even the policy practice was held not to frustrate the contract because it's argued that the commercial lease can still going on, which can be inferred from contract provisions allowing the assignment and subletting of the whole premises. So nevertheless, there remain several theoretical differences between the two doctrines, the Chinese law DCC and the common law frustration, in terms of the respective legal test, scope of application, and available remedies. My presentation will focus on these three elements. But before I go into these three elements, I would like to underline the philosophy behind the legal framework. And the Chinese law, the underlying basis for the DCC is grounded in the principles of good faith and fairness between the contracting parties. These principles have been contained as fundamental contract law principles under Article 6 and Article 5 of Chinese contract law, which has been incorporated in the Chinese Civil Code, which comes into effect on January 1st, 2021. In contrast, under common law, the justification for doctrine of frustration focuses on the lack of consent between the parties to perform obligation that is radically different from the original one. Therefore, unlike DCC, the rationale behind frustration is not so much to uphold good faith and fairness between the contracting parties, but rather to ensure the parties are not compelled to perform different obligations that fall outside of their consent. In view of the inflexible remedy of doctrine frustration, i.e. the automatic termination of the contract, the common law court cautioned against it for two major reasons. I may run the risk of oversimplifying things, but just in the interest of time, I just single out two major reasons for information. First, the court concerned about potential abuses by the parties to use doctrine as a tool to escape a bargain. The second is that it's not uncommon to see the price fluctuations and the sudden inflations in the real life. In other words, the contracting parties are expected to make provisions on force majeure and change circumstances to hardship in the contracts, particularly so in the commercial context. So while there are some overlaps at the policy level, the differences between underlying rationale of the two doctrines explain the differences in the legal test and available remedies. So let me start talking about the Chinese legal test first. Basically, the Chinese change of circumstances, DCC, was a creature of Supreme People's Court judicial interpretation. It's not a part of Chinese legislation. However, this year, when the Chinese Parliament legislature passed the Chinese Civil Code, the DCC has been incorporated into the Chinese Civil Code as Article 323. So basically, from next year, when we apply the Chinese law as governing law to apply, then the doctrine DCC is a default rule. So under Chinese DCC doctrine, there are 5 elements. The first is unforeseeable at the time of conclusion of contract, and the fault cannot be attributable to either party. And if the consequence is so serious that the outcome will cause manifest unfairness to one of the parties, and very interestingly, in the new Chinese Civil Code provision, they add up new requirement to qualify as doctrine DCC. That is, the negotiation is needed between the parties before going to the court or arbitration institutions. So they add up one more procedure requirement. Now turning to the common law legal test. I mean, the first starting point and the common law is to determine whether the contract has made provisions for the supervening event that has occurred. If contract has already made provisions, there is no room for doctrine of frustration to discharge the contract as a matter of principle. Secondly, the court would consider whether supervening event is foreseeable by the parties when concluding the contract. This requirement is similar to that of DCC and the Chinese law, with important caveats that the unforeseeability is not a strict requirement under doctrine of frustration. Whereas in Chinese law, this is one of the constituting elements of DCC. Thirdly, the court must be satisfied the supervening event is not caused by act or election of the party seeking to rely on it. This is also known as the rule against self-induced frustration. Lastly, the court will apply the court test of whether the intervening event is so significant that it renders contract obligation radically or fundamentally different from what has been originally agreed upon. There are three major categories: supervening impossibility, supervening illegality, and frustration of purpose. To summarize, comparing the legal test of two doctrines, there are significant overlaps in terms of the general requirement. For example, both doctrines require unforeseeable events that significantly affect the party's performance, and both doctrines exclude ordinary price fluctuations and foreseeable commercial risks. However, at the same time, there are also several conceptual differences in terms of the nuance, such as the necessity of the requirement of the unforeseeability, the scope of frustration of purpose, and the requirement of manifest unfairness between the parties. Now we move to address the legal consequences and the remedies. The next axis of comparison will be that of the legal consequences of the two doctrines. Under the DCC, where the court finds there has been a change of circumstances, the court shall decide whether to modify or terminate the contract. I have to stress here, under the Chinese doctrine of DCC, basically the court enjoys discretion to have this kind of modification power on top of the termination of the contract. This essentially confers the court discretion to rewrite certain contractual terms to ameliorate the unfairness caused by the change of circumstances. This stands in stark contrast with the legal remedies of frustration. The traditional common law position is that when a contract is frustrated, it will automatically come to an end and all the parties will be discharged from the obligations under the contract with prospective effect. So that simply means the loss will lie where they fall and each party will bear the respective losses. However, it's worth noting that the UK, for example, enacted legislation to apportion the losses when the contract is frustrated, namely the English law reform Frustrated Contract Act 1943. So notably, all money paid under contract before the time of discharge shall be recoverable and all monies payable cease to be payable. Under one of the provisions, I cannot remember, maybe section 2, subsection 3, if the party to whom the sums were so paid or payable incurred expenses before the discharge, the court may allow him to retain the whole or any part of that expenses. In a similar vein, in another provision, where the party obtained a valuable benefit, so-called valuable benefit, prior to the discharge of the contract, the other party can apply to recover from him such sum that the court considers just, having regard to the circumstances of each case. Although English court rejects the notion that the court has any power under common law to adapt or modify the party's contract in light of a frustrating event, the statutory remedies, which I just mentioned, in their practical effects, resemble somehow the process of modification. This will be explained further in the following. Before we move to talk about the case law analysis, I would like to give you some kind of statistics to show that how rarely the doctrine of change of circumstances under Chinese law to be pleaded successfully. And there have been, I just look into some kind of database of the Supreme People's Court and the High Court at the provincial level in China. Between 2009 and 2019, in 10 years time span, there have been only 44 cases concerning the DCC that have reached SPC in China, with only 7 cases being supported or upheld by the SPC in 10 years' time. At the provincial high court level, between 2009 and 2019, there are in total 234 cases concerning the DCC rule. This is either invoked by the claimant or used as defense by the defendant to exempt or mitigate the liabilities. All of these 234 high court cases, only 17 cases support the use of DCC rules. This number should be viewed against the total number of contractual dispute cases litigated at the High Court in this 10 years' time, which stand at 261,157. So large quantity of the contract dispute cases. So from these statistics, you can tell how rarely the Chinese court invoked the doctrine of change of circumstances and pleaded or upheld it successfully. So while the statistics provide some insights on how scrupulous the Chinese court applied the DCC rule, it may not tell you the whole story on the actual application in particular cases. Therefore, I find it necessary to single out 2 cases out of the 7 SPC cases in the interest of time. So I will evaluate whether the selected case studies would have been decided similarly under common law. The first case is called Xinshan Mineral Engineering. So in Xinshan case, the plaintiff leased its machinery to the defendant for the defendant mining operations at a particular site. However, after concluding the contract, the defendant discovered that the mining site has been damaged by previous mining techniques, and it was unsafe for the workers to start mining operations. After further investigations, the expert report stated that the machinery would no longer be needed. Then the defendant sent a timely notice to the plaintiff seeking to terminate the contract for the machinery, to which plaintiff refused and sought to compel the specific performance of the contract. So, make long story short, this case went to the SPC, right? Because there are 4 levels of courts under Chinese judiciary, but to make a long story short, this case finally, so we just focus on the reasoning provided by the Supreme People's Court. The SPC held that the contract should be terminated due to the change of circumstances because the discovery that the mining site was unsafe to commence mining operations rendered the purpose of the contract unrealizable. Since the change of circumstances was not due to the fault of either party, it would be manifestly unfair for the defendant to be liable to pay the original agreed sum that it didn't even use. But if the same factual metrics were to arise in Hong Kong or the UK, the doctrine of frustration will most likely not apply. That's my personal opinion, because the threshold is rather low. This is because the obstacles to performance had already existed at the time of contract formation, and defendant is not excused from performance simply because he discovered the obstacle after concluding the contract. This was the case in McDonald versus Corporation of Worthington. This shows that the doctrine of frustration places a heavy emphasis on the chronological order of the timing at which the obstacle to performance came into existence. So in the present factual matrix, as demonstrated in the Chinese case I quote, the damage to the mining site and the working conditions, unsafe working conditions existed before the parties enter into the contract. Nevertheless, even though the frustration might not be made out, the court, I'm talking about common law court, more likely than not, may arrive at the same outcome by setting the contract aside on the ground of other legal regimes, such as common mistake. It has been said that frustration and a common mistake deal with essentially the same problem, with the only difference being in the timing of supervening event. In the present case, it can be argued that both parties were mistaken about the common assumption that the mining site was fit for carrying out mining work at the time of concluding contract. Furthermore, the mistake was fundamental to the contract because it would have rendered the rental of machinery completely purposeless. Since the contract didn't allocate the risk of this mistake, and since the damage to the mining site was not caused by either party, the English court, I assume, may set aside the contract on the ground of common mistake, therefore reaching a similar conclusion as SPC in China. Let's turn to another case for a comparison. I only single out two. Sorry?
I think we are running out of time, so if you can shorten the rest of your presentation, that would be great.
Okay, maybe I'll skip this case analysis, but I think it's quite useful. And anyway, so okay, let me. I don't know what to do without this. Let me jump to comparative analysis. I cannot provide because I didn't introduce the case. And okay. Okay, let's talk about the remedy of modification under Chinese law. That is the most striking difference between the doctrine of frustration and Chinese DCC. There are four major points worth discussing. The first, it is, in my view, a misconception that Chinese court will simply disregard the parties' intentions by rewriting the contract and compelling the parties to continue performing the contract against the parties' wishes. Quite to the contrary, the SPC guiding opinions and the Chinese Civil Code stipulates that where there is change of circumstances, the party need to conduct new negotiations and amending the contract. Therefore, rather than going against the parties' intentions, the Chinese court is to give effect to the parties' intentions, encouraging parties to resolve the disputes amicably and agreeably between themselves. Second point, even when the Chinese court chooses to exercise the discretion to modify the contract, the actual modification still takes reference to the parties' intentions and original terms. This can be seen in the case I didn't articulate just now. The court consider how both parties intended for plaintiff I can skip this part. Thirdly, the third point, the remedy of modification offers parties a more commercially sensible solution in a situation where the contract termination was unfortunate because it undermines the long-standing business relationships between the parties. Comparatively, the flexibility offered by the option of modification could have preserved the parties' contractual relationship, mediating the unfairness to the supplier, at the same time saving additional cost for the buyer, for example, in searching for a new supplier. The last point I want to make is despite the criticisms leveled against the Chinese doctrine of DCC for allowing the court to rewrite the terms, the practical effect of statutory mechanisms under EIRFCA, the English Law Reform Frustration Contract Act, resembles the modification of original contract. By conferring onto the court wide discretionary powers to allow contracting parties to recover expenses and the valuable benefits that are not provided for in the contract, that would be practically speaking, akin to modifying the contract. Therefore, even if the English courts are not amending the term of the contract per se, the practical effect in such cases is intended to modify the contract so as to lead to a fairer apportionment of losses between the parties. In a nutshell, conclusion, contrary to the views of many critics, the DCC doesn't unduly undermine the principle of certainty of a contract and the party autonomy and the Chinese law. Just like doctrine of frustration in common law, the Chinese DCC has strict substantive and procedural requirements and is only applied in exceptional situations, as evidenced from the small number of cases that have reached the highest court in China. Furthermore, the SPC has instructed the lower court to apply the doctrine with prudence and to submit the decisions for prior approval or examination from the superior court or peer court, if necessary from the SPC itself. So these procedure safeguards further ensure that the Chinese doctrine is kept under proper check and limits and is only invoked in exceptional circumstances. So with that, I conclude my presentation. Sorry for being a little bit overrunning over time.